We are here today to announce the first ever felony wage theft conviction in the state of Minnesota. I am joined by representatives from SATUL, the Building Dignity and Respect Standards Council, the International Union of Painters and Allied Trades, and the City of Minneapolis Department of Civil Rights. After presenting extensive evidence in a trial lasting 4 days, the Hennepin County Attorney's Office secured a guilty verdict against Frederick Newell, the owner of a Minneapolis-based painting company. Mr. Newell was found guilty of wage theft for underpaying his employees assigned to a public works project. In total, Mr. Newell stole more than $35,000 in wages from 6 employees. We will not tolerate this type of behavior. Mr. Newell was entrusted with public funds to pay his staff for their labor on a public works project. Instead, he siphoned away that money for himself. Yesterday, Judge Michael E. Burns found Mr. Newell guilty. The case will now proceed to sentencing, which will occur on June 6th. The Minnesota sentencing guidelines presume a probationary sentence. It will be a felony conviction with the potential for up to 1 year in jail. The victims of this crime will have the opportunity to tell the court the impact of having their wages stolen from them by Mr. Newell. And labor unions may also submit community impact statements. The court will then sentence Mr. Newell. I want to thank the hardworking staff who investigated, prepared, and tried this case, including Hennepin County Sheriff Sergeant Detective Michael Hopkins, Hennepin County Attorney's Office Investigator Michael Murphy, Paralegal Patty Parlow, Legal Services Specialist Catalina Lara de Flores, and Assistant County Attorney Zach Desartels. This wage theft conviction is the first of its kind in Minnesota. It is an important step forward in our efforts to protect workers. Wage theft has a huge impact across the country, and it happens all the time, yet it largely goes unchecked. Robberies in this country accounted for $598 million in losses in 2018, while workers lost in excess of $15 billion a year. One estimate found that workers who experience wage theft lose 1/4 of their yearly earnings. In other words, workers received only $10,500 on average instead of the $13,800 that they should have made. When you are already living on the margins, that difference is unacceptable and economically devastating. Wage theft impacts younger workers and workers from immigrant and minority communities. Stealing from employees destabilizes working class communities, undermines economic mobility, exacerbates poverty, and ultimately makes our community less safe. And employers who follow the law should not be undercut by those who would exploit their workers. This system should have been standing up for workers long before. It has been 6 years since state lawmakers made wage theft a felony. And it is especially important that we take this stand now as we see our labor force mistreated daily by the privileged and wealthy in power in Washington. Our office wants to make it very clear. All workers have a right to be paid fairly for an honest day's work. This prosecution and conviction should send a message to all workers. Your wage complaints will be taken seriously and thoroughly investigated and prosecuted. And to those who would exploit workers while benefiting from their labor, you will be held accountable. We have promised to protect vulnerable communities, and that population includes workers. This may be the first successful prosecution of wage theft here in Minnesota, but it will not be the last. Attorney General Keith Ellison recently brought criminal charges against the owner of a central Minnesota dairy farm for wage theft as well. For far too long, rogue business owners in certain industries have taken advantage of vulnerable workers without repercussion. Those days are over. No business owner, no matter how wealthy, is above the law. Every business in Hennepin County will play by the same rules. Next, you will hear from Jordan Fry from the Painters Union.
Thank you. Good morning. My name is Jordan Fry, and I'm here from the IUPAT, representing painters, drywall finishers, glazers, glass workers, sign and display, and convention workers. But today I speak for all workers. For far too long, working people in our communities have been subjected to the underground economy, an economy that seeks to destroy worker protections. Often workers are paid in cash, misclassified, and exploited by shady business practices. As you will read in the now convicted case of Fred Newell and Integrated Painting Solutions, contractors will go to far lengths to exploit and steal from workers. Most times, workers cannot defend themselves. Vulnerable workers who can hardly afford to put food on the table. Workers who cannot afford to miss one paycheck. Well, I'm here to tell you and tell all those workers there is hope. This wage theft law serves as a beacon of hope, a law that turns wage theft from a civil court fantasy into a criminal court reality. But you must come forward to tell your story. We are here. We will stand up to fight wage theft and other worker exploitations. We will speak out and we will stand with you. We will not back down because we know an attack on one of us is an attack on all of us. We would like to extend our greatest depth of gratitude to all of our legislators who have heard our cries and passed the wage theft law. We would like to thank Hennepin County Attorney Mary Moriarty and her staff for working hard on this conviction. Former Hennepin County Attorney Mike Freeman for his leadership in bringing these charges to the forefront. Along with Hennepin County Sheriff's Office, Minneapolis Civil Rights Department, and Brian Walsh, Fair Contracting Foundation, and most importantly, all the witnesses who came forward. This is not possible without your courage and willingness to speak up. And lastly, us workers would like to tell anyone thinking of stealing wages from any worker in the great state of Minnesota that they better think twice. Justice will be served. Thank you.
Questions?
But for this law, if you wanted to bring a charge like this, what would you have used? Felony theft by swindle, or were there not any options?
There were insurance fraud options, theft by swindle, which Mr. Newell was actually convicted of as well. But this makes it very specific, which I think is really important, that wage theft, it's now enshrined in the law, and that specific behavior is against the law.
Mary, can you summarize how, in Mr. Newell's case, how he was, I mean, was this paperwork, or how did this theft actually occur in this instance?
Jill, do you want to?
Hello, I'm Jillian Deese. I'm the managing attorney of the Workers' Protection Unit. Unfortunately, the assistant county attorney who prosecuted the case, Zach Desatools, is not here, but there were multiple deceptive acts by Mr. Newell that led to his criminal conviction. So it included filing false payroll reports, for example, saying that workers had not worked when they had, in fact, indicating to the general contractor that he would hire his own employees, but then pay his employees as subcontractors. Informing intentionally his employees that prevailing wage standards didn't apply to certain types of work like touch-ups, when in fact it did, and then generally promising to pay back what was owed to the workers and not having done so.
Do you have to prove intentionality with this law? I mean, this couldn't be used to, if somebody did really make an honest accounting mistake, you
Right.
could charge them. I mean, they've got to know what they're doing.
Yeah, the statute requires intent to defraud, and frankly, we wouldn't want to charge somebody if it was an honest mistake. Part of the reason we created this worker protection unit, and we work in partnership with the Civil Rights Division, is there are going to be some situations where what is needed is education about what the law actually requires. But there are people out there, like Mr. Newell, who know exactly what the law requires and go to great lengths to do this anyway. In fact, the judge found that this was a very sophisticated type of crime, what Mr. Newell did, and it took a lot of effort to go into doing the things that Ms. Deese described.
What type of sentence would you like to see for Newell? I know the judge found there's aggravating factors, so
Yes.
there could be an upward departure, but what would you like to see happen?
Yeah, so I think it's important to differentiate what the statutory maximum is, which says any number of years. We are bound by the Minnesota sentencing guidelines, and under the guidelines, this is a presumptive probation case. It will still be a felony conviction, but that means that the months of prison time will be stayed or hanging over his head for a period of probably 3 to 5 years. He can, however, do up to 1 year in the local workhouse, local jail. And so we think it's very important to hear from the 6 victims who were directly impacted by this, as well as labor unions explaining how this impacts the community at large and businesses. So, realistically, we know it's going to be presumptive probation, but I think it was important. Zach Desautel's filed that, what we call a Blakely notice, and that simply means we thought this crime was more serious than the typical crime because of the number of victims, the fact that it had a major economic impact, and the sophistication of it. And the judge found that all of those factors were present. So I think it's important that people know, that this was intentional and that Mr. Newell went to great lengths to conceal what he had done.
How many other cases are you working on regarding this? Or regarding any new cases that you're working on? Is this like a one and done deal, or is there multiple around?
This is absolutely not a one and done deal. That is why we created the Worker Protection Unit. We now have a brand new senior attorney who we will be introducing, who's going to coordinate our efforts. We have prosecutors who are very interested in this kind of work. And what we are really working hard is working on our partnerships with unions. I think the issue for far too long has been just civil enforcement. So if you violated this, it would be a fine. It's not the kind of crime where a worker can pick up a phone and call 911. Many law enforcement view this, because it has been viewed, I think, by the criminal legal system as a civil violation. And so we are working in partnership with various federal organizations, local organizations, law enforcement. As you heard, we worked in partnership with the Hennepin County Sheriff's Office. So the idea is to partner with people who understand what these crimes look like, that they can investigate them and submit them to us. So we expect to see more of these prosecutions.
Maybe, Jordan, could you talk more about the union's role in this? Because I think that happened in 2020, then it was reported to the city of Minneapolis, which then referred the case to Hennepin County, which didn't file charges until 2022. So it's been a 5-year process. Could you just kind of unwind that a little bit and say what role the union played?
Yeah, it was just as simple as the workers had come to us in the beginning and trusted us, and we simply handed them over to the proper authorities and got them in touch with the Civil Rights Department and the Hennepin County Attorney's Office.
I do have something to add to that. Sometimes there are parallel investigations, in other words, a civil investigation and a criminal investigation. We are trying to figure out how to make these cases go a little faster because, as you've mentioned here, this happened years ago. And so if we are going to have a deterrent effect on this type of behavior, we would like to be able to act more quickly. Part of that, and one of the issues that happened in this case, was that in the scheme of what the judges hear in Hennepin County, this was a relatively low priority case. Every Monday, there are anywhere between 90 and 120 felony trials set every Monday here in Hennepin County. And the district court prioritizes them by cases that are in custody, cases that are sexual assault, person-related, violent offenses. And these cases tend to be at the bottom of the hierarchy there. And so that is why we worked with the court, and I think we'll be doing more of this, to encourage them to set aside a judge to hear these types of cases, or to make sure that they are heard, because otherwise what happens, and did happen in this case, is it got continued many, many, many times. And that caused great frustration, understandable frustration to our partners, to us, frankly, because it's hard to hold people accountable when they know they're not actually going to see a judge. So we will be working on that. I know our labor partners, we've had conversations with them about talking to the bench about, hey, can you do something about prioritizing these types of cases so that we get them resolved and that the people responsible are held accountable?
So is there a parallel civil action going on? Is Integrated Painting Solutions still a business? Have they gotten shut down, fined, anything like that on some side?
Brian Walsh.
Good afternoon, everyone. My name is Brian Walsh. I'm an Associate Director of Civil Rights in the City of Minneapolis. There was a parallel civil administrative investigation, and that was resolved by the general contractor in the case, which had a contract with the City of Minneapolis. There were wages recovered at that time, as noted in the theft by swindle and charges and order issued by the judge.
Is there anything that prohibits the defendant here from doing business again in Minnesota or in the city, or is it just
The defendant is effectively debarred from working on City of Minneapolis funded projects, and I'm sure that state authorities will be pursuing similar debarment.
okay, but he could still do a private job for a private contractor. He's not out of business, right? No, that's not, at least at this time, that's not part of his order or sentence. Okay.
Other questions?
Thanks for your time.
Anything else? Thank you.